this morning saw a significant legal win for the murderer Graham Dwyer. Newstalk court correspondent Frank Greaney joins me on the line now. Frank, it wasn't exactly unexpected, but it's still fairly significant.
Yeah, I think that's fair to say, Anton. The reason I suppose we were expecting this outcome is because the legal advisor, the Advocate General to the European Court of Justice back in November, gave his opinion and I suppose his advice to the court after hearing the submissions from both sides last year. And in November, he certainly seemed to lean on the High Court's decision back in 2018 that ruled that, you know, the general and indiscriminate retention of mobile phone metadata, which is traffic and location data, that was in contravention of EU law. So while that wasn't binding on the court, it was a really good litmus test. It was a really good indication of what way the court was going to rule. And that's exactly what's happened today. So certainly not unexpected, but definitely has huge ramifications for the way An Garda Síochána investigate serious crime in this country and the way police forces right across Europe investigate crime. And the reason for that is they no longer have access to that metadata. And that has, over the past few years, proved crucial in many prosecutions that have come before the courts.
Let's look at the Dwyer case specifically in a second, but just so that I have the understanding correct, the way the Gardaí would use this kind of information is they are able to get from the phone countries or from the phone companies which transmitters the phone was conversing with, and by doing that they can triangulate the position of the phone and therefore where the person who owned the phone was, and that goes a long way to be able to say, well, there you were when you sent this text, there you were when this incident happened, and they can stitch together the evidence of a crime. They won't be able to do that anymore.
Precisely. That's exactly it. And call records have also proven useful. So while you might necessarily be able to tell who made the call, you will be able to tell that a call was made from a certain handset to another certain handset that might be relevant to a Garda investigation. You'll be able to tell the time that call was made, how long that call lasted, and as you say, through cell site analysis, you'll also be able to give a jury, if one is required, a good estimation as to where that call was placed from. It won't be exact, but it'll be pretty close. That has been used to great effect in lots of trials, including Graham Dwyer's. This metadata that was taken from a number of handsets that were discovered as part of the investigation into Elaine O'Hara's murder back in 2012. A lot of this evidence was put to the jury during the high-profile trial of Graham Dwyer that resulted in his conviction for the murder of Elaine O'Hara. And that's exactly why we're here today, because on the back of that conviction, Graham Dwyer went to the High Court in 2018 and he won. The High Court agreed with the arguments that his legal team put forward in relation to that law. The state then went to the Supreme Court to appeal that decision. Obviously, given, I suppose, the ramifications and the implications of it, that's why the state went to the Supreme Court. The Supreme Court then sought clarity on a number of issues from Europe, and they have offered that clarity today and will leave the Supreme Court in no doubt as to the lay of the land in relation to those issues, because the Supreme Court is now bound to uphold them.
Now, if I remember correctly, it's hard to overstate the significance of the telephone evidence in the Dwyer case, because there was precious little in the way of additional forensics. A lot of the evidence on which he was convicted, I think it's fair to say, was the text messages and positioning of the respective phones, wasn't it?
Yeah, the case itself was entirely circumstantial, and I think it is fair to say that the evidence harvested from a number of mobile phones relevant to the investigation certainly proved crucial. I think it's fair to say, proved crucial in the prosecution of Graham Dwyer, given the fact that there was no smoking gun. To this day, we don't know exactly how Elaine O'Hara died. Elaine O'Hara's skull has never been recovered, so there isn't a conclusive cause of death. So certainly this was a circumstantial case. Now, today's decision, it's really important to point this out, that this wasn't part of Graham Dwyer's criminal appeal. Yes, it will strengthen his hand, no doubt, when he eventually moves to appeal his conviction for the murder of Elaine O'Hara, but he hasn't actually brought that appeal yet. Again, this will have to go back to the Supreme Court. The Supreme Court will make its ruling in due course, and it's fair to say that it will be, you would imagine, in lines with the decision that was handed down today, because its hands are tied when it comes to a decision and a ruling like that handed down by the European Court of Justice. When all that is done, then Graham Dwyer is likely to move that appeal. We don't know how many grounds of appeal he's going to have, but certainly the admissibility of that evidence was an issue at trial. It was an issue that needed to be thrashed out in the absence of the jury, whether or not that evidence could be put before a jury. It was allowed. Obviously, we don't know what weight, if any, the jury put on it in their deliberations, such as the sanctity of the jury room. But certainly, today's decision will strengthen his hand. That's not to say that it's going to be automatically overturned. That will be for another court to decide on another day. That will be for the Court of Appeal to decide on all of the issues.
But I think, Frank, when people listen to you describing what the implications of this judgment, they will reflect back on the Dwyer case and remember just the brutality, the sadism, the cruelty, the exploitation of somebody who was vulnerable, the willful abuse and ultimately brutal murder of an innocent woman. And reading between the lines, it would appear that he's now going to be able to say, well, this verdict means that all of that evidence in respect of the telephones on which I was convicted to some degree or another, as you say, we don't know what the jury deliberations were, but he will be able to go into court and say, you now have to throw all that out.
He can certainly make that argument, but it's also important to remember that the Court of Appeal in due course will obviously be allowed to look back at any other evidence called and heard during the trial, and it could also decide that the investigation team was acting in good faith when it accessed his phone data. In other words, they didn't know that they were breaking any laws or regulations by doing so. Again, that could be an argument put forward by the state. What weight, if any, the Court of Appeal will give it will be interesting to see. I mean, the reality is that this law, the European Court of Justice, struck down the EU directive underpinning this legislation, which was enacted in 2011. It struck down that EU directive in 2014. And that was following a case led by a campaign group called Digital Rights Ireland. It's a case that we covered extensively on Newstalk at the time. So since 2014, that law, it would seem, has been in contravention of EU law. And if there was any doubt in relation to that, that's been put bed today by today's ruling. And it does have wider implications. It's very rare for me covering cases involving organised crime before the Special Criminal Court where this type of evidence isn't used and where this type of evidence isn't used to great effect. Serious criminals are forensically aware. So more often than not, it's not that unusual that you would get a case where the bones of the evidence is in that metadata, where certain phones were at certain times, when certain calls were made to certain individuals at various times relevant to an investigation. It's tedious stuff, and sometimes it takes days and days and days for an investigation team to put this evidence before a jury or judges of the Special Criminal Court, as the case may be. So certainly for An Garda Síochána, for those specialist units that combat organised crime, and for police forces right across Europe, this is a good day for Graham Dwyer, yes, but it's a bad day for the crime fighters across Europe.
And does that mean that there is a possibility that we will see an influx of appeals from drug dealers, drug importers, violent criminals, murderers, all of them saying, well, OK, I'm going to go down the Graham Dwyer route and question the applicability of this evidence?
That's a brilliant question, Anton, and it's something that the in its ruling today, the European Court of Justice did rule on. So as I mentioned, this law was declared invalid back in 2014, and in its judgment today, the European Court of Justice said that our courts in Ireland, national courts right across Europe, can't impose a temporal limitation on the effects of a declaration of invalidity of a national law that provides for such retention. So that would suggest that, as soon as that law was declared invalid, our courts couldn't put a temporary stay on the effectiveness of it. So it'll be interesting to see now over the next while the Court of Appeal list. We'll see how busy that gets. But again, while this evidence in many cases, certainly before the Special Criminal Court, is often crucial, There are cases. I mean, it will be taken on a case by case basis. Obviously, I mean, the admissibility of that evidence may be called into question, but you have to remember that there is other aspects of evidence called before trials. Obviously, you do find cases where this type of metadata is the kind of the most important plank of a prosecution's case, but it's not always the only one. And sometimes, more often than not, certainly in circumstantial cases, there will be lots of threads coming together in the tapestry of the wider prosecution's case. So, yes, this is a good day for the likes of Graham Dwyer and other cases that may have relied on this type of evidence. But it doesn't mean there's automatically going to be convictions overturned and people walking free from prison.